So welcome. Today we're going to talk about case management, specifically case management in family dispute resolution. So before I proceed any further, I'd like to acknowledge Aboriginal and Torres Strait Islander peoples as the traditional custodians of Australia and pay respects to elders past, present and emerging. I come to you today from the lands of the Gunai people in southeast Victoria. I'm Joanne Law. I think everyone here knows me, so welcome. Please use the chat to introduce yourself there if you're able to. It's a little bit harder if you're on a mobile phone, but it would be great if you let the others know who you are and where you are. So what I've got on the agenda today is to just have a look at what we mean by case management, what the purpose is, some of the planning and control procedures that we need to use as FDR practitioners, a little bit about risk management, preparation for mediation, referrals, and there might be some what else. What I'm using as a definition about case management, it's a collaborative process that assesses, plans, implements, coordinates, monitors, and evaluates the options and service required to meet clients' needs. So we're looking at that full scope of what we need to do in order to, one, fulfill our obligations as FDR practitioners, and two, try and provide a service that's best going to meet the client's needs. So it involves communication with our clients, other team members, potentially other organisations. Remembering that even though our process is confidential, clients can give permission for their information to be shared. We want to not hide behind confidentiality, even though it's very important that we manage that in a very appropriate way. And of course, we have our mandatory reporting, our duty of care obligations, and we can share client information internally in supervision and into statistical ways as well. So there's a lot more nuances than anything that's said is going to be confidential. Appropriate service delivery. So within the framework of our regulations and the obligations we have to our parties, and of course those silent presences in the background, the children that may be affected, and sometimes other people who may be affected. Resource management. So good case management makes effective and efficient use of resources. It's that comes into time management. In some situations, it also comes into the risk screening and the sorts of cases that you might take on, but it does also imply an obligation of, if you can't help people, if your requirements are that you need to issue a Section 60I or not proceed, where do they go to? What's the next step for those people? And of course, client outcomes management enables quality, timely, cost-effective client outcomes. So if you're working, and I can see some of you are working or have worked within FDR services, the case management is usually managed by a number of different people. You may not do the initial inquiry work, you may not do the initial screening and risk assessment. Hopefully you're probably involved in a discussion about what should happen based on the information collected in that risk screening and in the preparation for clients. You may be participating in group education sessions for clients, so a whole lot of different activities and roles. If you're in a private practice, you may be doing a lot more aspects of the work yourself, but you may also be making greater use of external referrals to resources. So that's the big picture of what we mean by the case management. It's not the same as the Federal Circuit Court of Australia, Federal Circuit and Family Court of Australia. I've left off at FC. Case management. The central practice direction outlines the court principles for case management, but that's only really if clients end up in court. But it is important for us as FDRPs to understand what happens if people do go to court, and there have been some changes that have happened since the merger of the court, and in particular the central practice direction. It's a case, the purpose of the central practice direction is really clearly articulated in the Family Court's website and in the documents provided. So hopefully everyone here's already had a good look at that and read it, but if not, it's good to just remind ourselves that it's got three key principles or purpose elements. So reduce unnecessary cost and delay in family litigation and facilitates proceedings being conducted with the least possible acrimony in order to minimise harm to children and families. Ensure that the safety of families and children and achieve the overarching purpose of the Family Law Practice and Procedures provisions of the Federal Circuit and Family Court of Australia Act 2021, being to facilitate the just resolution of disputes according to law and as quickly, inexpensively and efficiently as possible. As I was preparing this, I was wondering, does your case management system have an overarching purpose? Do you or should you have a guiding purpose of what you're trying to achieve in either your professional practice or your FDR service? And maybe just using the chat, does anyone have a purpose statement around your case management the way that the central practice direction has? I know we don't in Interact support, the service that I'm part of, but I think we should. Now, as Mediation Institute provides training to FDRPs, I always go back to the qualification to have a look at what are the elements of competency around any particular area of focus. There's three big areas for FDRPs that I think the risk we all are very familiar with, but sometimes the collaboration and potentially even the referral is a little bit understated. So with collaboration, what's expected in terms of competencies is the ability to negotiate and liaise with other areas of the family law system according to the specific client needs. And that may include the police, legal services, allied program staff, familiarity with the relevant legal responses and programs, in particular with regard to family violence and other issues. We need to be very familiar with the family violence intervention orders in the jurisdictions that we work, being able to read them, to know whether or not FDR is appropriate, to know whether or not a parenting plan or a parenting agreement that's reached is going to be allowed to take effect, knowing where to seek expert clarification of family law and actually of the family violence legislation as well. Family dynamics in different cultures and how they may impact the provision of services. So the collaboration may extend to the various community groups within your organisation, providing information and also gaining information about some of the factors in that culture that may be present in some of the families that come from those particular backgrounds. Establishing referral practices and making a collaboration an integral part of your practice and building networks with relevant service providers. So is that something that everyone is seeing as essential part of your practice? I know those of you that are on the course at the moment in the practice case management assignment, we make you go out and look around your local area and find who the services are. You're all being very quiet, so if any of the existing practitioners we've got on the call, if you'd like to share, if collaboration is a part of your practice of making sure that clients do get the support that they need. In terms of risk, this is certainly, I would hope, seen as core work for any FDRPs. The case management principles around assessment, planning, monitoring and reviews. We need to assess the risk. We need to plan how we're going to implement the services. Are we going to use shuttle? Are we going to use online? Are we going to put in place any other protective strategies? Do you need to if you are doing things in person, do you need to let others know? Do you need to plan for a debrief afterwards? Monitoring, so we're doing constant monitoring and review to make sure that the risk hasn't changed or our perceptions of the risk haven't changed and that we don't need to modify. And then, of course, reviews. Checking in with clients afterwards may or may not be part of your practice, but if there have been risks identified and vulnerabilities, then that may need to be part of the case management to see whether or not they have actually got the supports in place. Processes to implement the case management principles consistently. So again, making use of screening tools and things like that, so that we ask all of the clients all of the risk screening questions, not just what seems appropriate based on how they present. And the types of risks that parties can be considered, the types of risks to parties considered in dispute resolutions. We need to be looking at other options that may be more appropriate for particular clients. If maybe there's child sexual abuse or child abuse or other aspects that we believe need to be investigated, so it might be a mandatory report. It may be that the court and some of the specialist lists might be a better area for this particular family. Do we need to involve the family violence sector? Around risk as well, the community, educational and other resources for referral or use within the process. So what resources have we got for clients? Just talking to someone and telling them something is generally not enough, because we know that our clients are often in a state of quite extreme overwhelm and their retention isn't the best necessarily. So having resources that they can access later, perhaps with someone who can support them and they can absorb the information a little bit more. Then, of course, the more theoretical or practical, really, concepts of planning and control procedures, resource management and risk management, knowing how to put risks on a matrix or a hierarchy of the potential of the harm that may occur, and the likelihood and the urgency is usually the characteristics that we're looking at about for risk management. And then the other competency that's expected of you is referral. So having referral options and systems available for clients who may need to have their needs met by other services or experts. So sometimes that can be done internally. So you might be in an organisation that's got a counselling arm, that's got child contact services and other things, or you may be working independently where you need to find out what's available to clients and be able to refer them. And that flows into the community education and other sorts of services that are available. Three key areas: knowing how and when to collaborate, managing the risk, and referring clients to other supports. So again, just a little bit more graphically in the pre-mediation phase. So before we get to mediation, that flow of each step from the inquiry to receiving and giving information to clients, invoicing, getting paid for the services, the risk screening, preparation and referrals, and then your mediation, again, preparation, invoicing, the actual mediation service and any referrals that flow out from that. And then after the mediation, writing up any documentation, again, referrals, resources, and whatever follow-up schedule you decide to put in place if you do. So you're very quiet back there. Any thoughts or comments? Is there anything missing? Is there anything that hasn't been, I suppose, highlighted enough in your thinking? Please feel free to let me know.
It's Mary.
Sorry.
I'll wait.
No, you first, Mary.
Yeah. You go.
Oh, I was just going to say, so for the risk screening, are you predominantly using doors as well?
Yeah, I certainly do. There's a number of different processes, and as you're probably aware, the court's now using
doors,
so it's nice that it flows within.
It's what we use here too in post-set for our programs for counselling, and I thought, that it would be a very familiar template, I guess, to use, and a good one, I would think.
Yeah, absolutely. And if you're doing a warm referral, then you can ask the client if they want you to pass on the doors that they've done. So some of those things, particularly if you're referring to other services who also use doors. So one of the complaints that clients often have with services is that they have to keep doing the same detailed story over and over again.
Yeah, true. That's true. Whereas if you've got that permission to almost share that document, then they don't have to keep reiterating it. And it's quite a good document, obviously. The courts use it. Most people do. What other options apart from doors would there be?
Look, there's a MASIC is another one. There's a few different mediation risk screening tools used in other areas. But with whatever you're using, you're still going to need to have an interview. You're still going to need to talk through with people.
For sure. Yep, to clarify. Yeah, definitely.
Yeah. And the doors, I like doors and it's good. The problem is, for me, is that some of the questions are really time bound. And if people are literal, they're going to just answer yes or no according to that time frame. And as we all know, a significant incident that happened a little bit longer ago than that is still going to have ramifications.
That's very true.
I mean,
That's a very good point. And then, so you use that obviously in the pre-mediation phase, and then you can
yeah,
use it for a pre-interview sort of thing once you've done the doors.
yeah, absolutely.
Yeah. Okay, excellent. Thank you, Jo. I appreciate it.
No, not a problem. And there was someone else to make a comment. It takes a moment to get you.
Can everyone hear?
Yes.
Hello?
Yes, I can hear you.
Yeah, I'm trying to get the video screen. Some people have found the door screening overwhelming, some clients. I've had the experience of working with the family court and at the coalface.
Yeah.
So it is interesting. You have to find a balance because there are some people that can get incredibly stressed. So it's so important to actually talk.
Yes.
With them.
Talk through.
Are alarming for some people. They're not all literate. They've got issues. But that was something that was noted.
Very much, yeah. It depends on, literacy is a big issue, and if people have got trauma as well, that unsupported, it can really cause a upset. So we need to, and that, I think that's a really important part of case management, is we need to be able, we have to have the flexibility to adapt to each particular client's needs. So rather than just sending out a link saying, do you have access to a computer? Are they going to be trying to do this just on a mobile phone? Is that going to work for them? Do they need support people? So all of those sorts of questions really need to be asked at that initial stage.
That's so true as well, Jo. We found as well in post-separation, a lot of people are too hesitant to actually fill out the doors in a truthful manner because they think if they give too much information, they're almost going to be excluded from our programs, or they're not going to be seen as being the right fit. So that interview, very much so off what you've both just said, is so important because that actually gives us the platform to go, you know what, so you've written this here. Can you tell me a bit more about that? And then actually divulge what, that's actually really relevant before going into counselling. So it's the same thing, I assume, for mediation. That's where you're actually able to find out what's going on.
Absolutely.
A lot of the time.
Yeah, the tools are useful, but they're only tools. You really need to remember that the interaction with the client is where we're going to get the real information, or as real as we can get.
Couldn't agree more. That's so true. Yeah, Jo.
Based on the level of trust and rapport that we can establish. And Verity, I think you had a comment as well.
Yes. I don't have any further comments, just that you have to personalise it. And if we don't personalise it, you lose them.
Absolutely. Yes.
It's that straightforward. And the world is inundated with questionnaires.
It is. Yeah, so they're useful, but they're only tools. And I've got this map, which in a way is kind of highlighting the overwhelm that can happen for clients as well. We've got the course and mandatory information that we have to provide from the regs and our other obligations. There's mandatory information we need to collect. So we need to collect risk screening information because we've got an obligation to determine whether, based on the history of family violence and a whole lot of other factors, we expect that the people will be able to negotiate freely, and if not, we must not provide FDR, and if we think that they can, then we may. But then generally there's other information that we need to provide, and then there's other practical information we need to collect to efficiently and effectively manage the case. It's quite a bit of information. Again, we always need to go back to our regulations. The FDR, or Family Law, Family Dispute Resolution Practitioners Regulations 2008, they're currently being reviewed. We don't believe they're going to be major significant changes, but there will be some in due course, a new version of the regs because they're sunsetting. Hopefully they'll update the Section 60I certificates. The Clause A isn't so hard to read. And that's an example of other information. So when I do need to send out a certificate saying that the person I'm sending the certificate to, naming them, didn't attend because of the other party, I have a little explanation thing that goes with it, because I learned early on that otherwise you end up with people coming back, oh, it was them that didn't turn up, not me. I don't know if anyone else has had that experience. So as I said, the regs, and there's the two different legislation portals that you can look that up. So Regulation 25, that relates to our assessment of suitability. 26 is the Section 60I certificate. Reg 28 is the information to be given to parties before FDR, and that's really important that we do comply with those regulations, and that you don't just do everything over the phone or something like that. Like, you need to make sure that the people have the information that we must provide. And of course, being aware of the obligations that we have, and all of those should be embedded into your practice management, your case management system. And when we're talking about information to client, there's problems with any format. Verbal, mostly people aren't going to remember everything that you say to them. Written, they may not read it, they may not be able to read it. Are there disabilities or other barriers to access that make it inaccessible to them for one reason or another? What else do we need to think about? What are people doing in terms of making as much as you can sure that people are getting the mandatory information? Written and verbal, yeah, I agree, Carol. We need to at least provide in two different ways. And of course, with our invitation to Party B, we have an obligation. We must attempt at least twice, and once of those in writing. So sometimes that's a requirement, but it's also a very good, often multiple times, yes. Because people are in overwhelm, they may be dealing with grief-related issues, and we've just had a really interesting couple of sessions with Mary, leading us thinking about grief and looking at a newer model of thinking about grief. That can certainly be a barrier to people taking in information. We need to be really thinking in our case management of, do they have the information? Checking in, using our mediator skills rather than just blah, 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 asking people, what did they understand about that? Asking questions so that they don't just say yes because they don't want to seem silly. All those sorts of strategies as well, particularly if we have got concerns that someone's cognition may be impaired, or, for other reasons, they may not be following what we're saying. Additional information. So with the government-funded services, there's usually going to be a course or workshop, Child in Focus or whatever it's called, within the organisation that may be helpful for parents. There's other services like some of the co-parenting apps that have got education and that happening around them. Interact Support, the not-for-profit I work has got an arrangement with Bill Eddy and the New Ways for Families course that's available online for people. Information guide. So I think most practitioners would have an information guide that goes into a little bit more detail about parenting, whether it's looking at guidelines on what's good, safe parenting and what might be problems, guidelines around property to help people prepare, and of course resource sites and referrals. Things have changed with the use of the internet, and so many FDRs now happening online. So it's not once you just have your little referral list of your local area because that's where your clients are going to be. Now your clients might be all over the country. So the need to have a referral list that, or some mechanism for finding resources for clients from all around the place. So Ask Gizzy is one that I'll often use. The Family Law Referral and Advice line. Have you got an in-house tool? So what are people doing to manage knowing, getting additional information to clients, finding referral information?
I find it really helpful going to conferences and things like that to be able to develop those networks.
Yeah, it's really very good if you actually can know the people running an organisation or services, because, yeah, there is some variability out there. And I suppose checking in with clients that you have referred to make sure everything's gone, that's another option if you've got the ability or resources to do that.
I was also thinking about if there was like a process so you could develop a relationship with another organisation so that whenever there is a referral that's made, that there's a commitment that there will be some information shared back.
Yeah, absolutely. And that fits within the collaboration frame that we talked about right at the beginning. That is an expected competency. Yeah, getting arrangement around what information shared, what confirmation comes back, and creating that circle of support. What about referral or resource sites and information? Is there anything else that others are using? So sometimes I might send people to the Circle of Security if I think that maybe their parenting style is overly firm or if I think they need to look at the full picture of what children need, that they need loving support, but they also need support to explore and develop. Anything else that anyone uses? Triple P parenting, yeah.
Yeah, Triple P is brilliant. PET, like parent effectiveness training as well. We obviously run a suite of psychoeducational groups here as well in my family skills team, like parenting after separation, navigating parenting as well, resilient mums, resilient dads, which help you build up and learn strategies around increasing your resilience as a parent, how to co-parent more effectively, and how to deal with sort of the grief and loss of losing the identity of you being someone's partner and being a parent in a nuclear household, and how that's now changed, things like that. But yeah, FRCs are really good for that. There's a lot of us out there that offer these sort of programs.
Absolutely, yeah. And they're really effective. Some of them have got programs around blended families, another big stressor when, different parenting styles come in with formed already children. I'm not sure. They might be you, Mary. You're coming across very funny. Yeah, and also individual support services for parents. Mention resilience, Erin, and it's really important because a lot of the ongoing family violence and things like that happen when parents get stuck and they're not resilient, and they get caught up in their anger or grief or whatever emotions and can't move beyond.
Very true.
Yeah. So helping them to access individual or group counselling, that can make a big difference to shifting their perspective and helping them to be more open.
Absolutely. I couldn't agree more. And that's what, builds that resilience. And ability to co-parent more effectively, because it's often those small nuances, I suppose, that children pick up on as well regarding how parents treat each other, even just in small interactions, even at a pickup or a drop off. Or kids are so switched on, they really pick up on it. So it's being aware of those little things, and those cues. Yeah,
absolutely. And a really common strategy that parents use is they don't want to fight, so they don't talk at all. Like they do this whole drop off and pick up with not a word exchanged. And that
can be even more hostile, right? That can be interpreted as even more hostile instead of a hi, how's your day? Simple. Absolutely. So true.
Exactly. So getting that information, and when it's presented in a group or in a course or in something pre-prepared, people realise that you're not picking on them.
Exactly. Spot on. And that there's other people in the group experiencing the same thing as you. So you know what, it's a safe space to bring it up, and you're not being attacked. It's just a common theme that's occurring. So let's talk about it. Yeah.
Very, very much. So I didn't highlight around here around child inclusive practice, but as the changes come through the system, hopefully that's going to give a further push towards using some of those practices where the children's experience can actually come into FDR a little bit more. And some of the FRCs and Relationships Australia have got those resources in-house. But even there, it still can be very difficult to get parents to engage in that process for a variety of reasons. I did a presentation a few weeks ago about the Family Law Amendment Act, and we're waiting on the second act, but we had the Family Law Day at the start of the month as well. Anyone who's a member or a student, you should have already received or was registered to attend, you should have already received a link to that. So that's well worth finding the time to have a look at what the AG's department had to say about the Amendment Act, and Senior Judicial Register Anne-Marie Rice had to say about court and the support for mediation, and of course the other sessions as well. But these changes are going to necessitate all of us reviewing our documentation to make sure that they're ready for the changes. We're going to have to change the definition for best interest of the child, which hopefully you do have already in your documentation based on the current system, and the mandatory information that we had to provide to parents around them considering shared care or whether significant and substantial care arrangements are going to be reasonably practicable. That section of the Family Law Act has been repealed, or will be repealed on the 6th of May. Now the focus is very much on the children and what's going to be the best for their care arrangements. It is a process that's going to take some adjustment, and we'll have some more sessions, probably some more discussion-y sessions where we can talk about what this is going to look like. How do we change our spiel? How do we continue to? One of my kind of lingering fears is that the children will be seen by parents that they need to put a little bit more pressure on children to sort of pick sides, and I hope it's not the intention, and I hope that's not going to be the outcome. But I think it's important for us to think about how we can help with the information we share and the way we talk about things to prevent that from happening. With Interact support, we developed quite a big document, which is much too big for anyone except for those parents that are really seeking information, and there are quite a lot of them. So there are a lot of parents that get into this strange new world of separation and divorce and start avidly reading and accessing every resource that they can. But so we developed that. But as society's evolved and a lot more people are just taking in information from videos and snippets and smaller pieces of content, we're looking at how we can resource changing the format into much more bite-sized bits. But there's quite a big meal there, so it's not as easy. What are others doing? Random question, Carol, about whether we see the changes will result in more sole parental responsibility orders. Look, it's I would think probably yes, and possibly in some of those cases it's because there are situations where the parenting arrangements are being used as an ongoing extension of family violence, and that presumption of, or that need to consider shared care arrangements has led to people frightened that they'll lose care of the children, agreeing to things that perhaps aren't in the best interest. But I think it may also have some negative repercussions. Hope not. Let's all work together to try and keep kids safe and having that ongoing connection with families where they can. Yeah. So with your referral networks, of course, the AG's department map, which is good. It now there, have you checked, if you are a practitioner, have you checked your listing? Are you showing up on the map and things like that? Mediation Institute's just about to launch a new member platform, which will see an update on what we have been using as our map, and there's other referral networks around. There's been, I guess, just a point, paying referral fees is considered unethical in our industry, and because it could be seen as compromising our impartiality. Occasionally you do get requests or offers from people to send clients and having a referral fee. It's really not something that you should be doing. Paying to be on a directory is okay because there's not a direct this client and a fee payment for them. So any questions or thoughts about that? Has anyone been in that situation where someone's approached them about referral fees? No, hopefully not. But yeah, it's just something to steer well clear of. Resources, and I haven't put in, but there are a couple of fact sheets on the AG's site about the amendments. So just go to the website and search for family law amendments, and you'll find them. One of the fact sheets is for parents and one is for professionals. Family relationships online. They do have resources for FDRPs. If you weren't aware, you can ring up and speak to a lawyer there. If that's one of the possible places for you to get some advice about legal matters. Hopefully you've got some in your network that you've vetted and are referring clients to if they need legal advice. Some of the FRCs have relationships with firms that do PD sessions and are available for these sorts of discussions. And I'd really recommend that any FDRP does have a network of lawyers are supportive of clients trying to resolve issues out of court. And of course, your professional associations, the Family Mediators FDRP group on Facebook. So I had a look today. We've got 823 FDRPs and students there, and there's always lots of active discussion and scenario type cases. As with any group, sometimes we get a little bit of adversarial stuff between lawyers and mediators working in FDRPs working in services and independence. We jump on that as soon as we can because we're all here working together to try and help people look after their kids as they go through separation and divorce. We're not the enemy. Conflict's our enemy. So yeah, make sure that you've got, I guess what I'm saying is making sure that you've got as many resources available to you as you can. Australian Institute of Family Studies, it brings out some really great resources and research and webinars. And if you are working nationally, they've got a really good resource on mandatory reporting so that you know how to make a report based on where the children might be. So having you don't have to reinvent the wheel. There's people putting together really useful and effective resources. Your family law pathway network may be a really good network for you to meet other professionals working in the family law sector, as well as sometimes they have registrars or judges or others presenting. So are those here, are you part of your local family law pathways network? Yes. Thumbs up. Yep.
Yeah, I am. Yeah, I'm the Family Law Pathways Network representative for our organisation. Yeah,
Well, there
absolutely
you
love
go.
it. I've been doing that for 2 years. Love
Yeah.
it. Yeah.
Oh, excellent.
Yeah.
You'd be very good.
Thank you,
Yeah.
Jo.
Yeah, and it's a really important part of making sure that we do understand what's outside the boundary of our work. And that's important for everyone working in this sector, because it's those gaps between that clients can fall down. Yeah. What are the sort of things that your network does?
Quite a few things. We focus heavily on offering training and how we're going to offer those sorts of training, because we have a pool of money, and we have a coordinator, Yana, she's from this organization. She's fantastic, and she coordinates all of us. And yeah, we talk about the different trainings we can offer. We talk about a lot of the changes, like the Family Law Amendments Act, a lot of those changes. Bruce Smythe is also a member of it, so he's a whole plethora of knowledge. Yeah, we just talk about a lot of changes, a lot of things that are happening. We also communicate with each other regarding changes that are happening with each of the FRCs and the private law firms. And it's a really good way to communicate with each other, because we have a lot to do with each other in regards to when we get Section 862s or Section 16A requests. And it's good to put a face to the name when they're asking for this information. It's a bit of a give and take sort of thing. And you start to get to know each other, who you're talking to. And it's really good. We work so closely together. It will, in my role, and that family law space, we work very closely together. So I'm very grateful to be on that sort of committee.
Oh, that's wonderful. And which pathway network are you in?
ACT.
ACT.
Yeah, ACT.
Yeah, no, excellent. Yeah, so anyone that's saying, "Whoa, that sounds good. Why aren't I part of that?" Yeah, contact your local one. Some of them, the culture is a little bit tricky for private FDRPs, which is not good. But surely yours isn't like that, Erin.
No, they're quite inclusive. I know what you're talking about, though, Jo. I have heard that, yes, but they're quite inclusive. A lot of FDRs are already family lawyers, so they've gotten in that way, or they have training in FDR, even if they're not practicing at the moment. They're quite inclusive. So far, we haven't turned anyone away. It's more, they really only take sort of one representative from each organisation, maximum two. It's more, if you're coming from an FRC or you are a private practitioner, you can get in on it. It's just usually only one of you can attend, to keep the group size at that sort of, because we all meet face to face. And so they're quite good. The information I get from that and the networking, and just even knowing who to reach out to in that family law space when I've had questions, because I don't have a law degree, has been very useful for me throughout my journey. It's been very useful. So yeah.
That's great. And it's great to hear that people in Canberra are going across the bridge and going.
Yes, absolutely. Absolutely. So no, very valuable. Yeah.
Oh, wonderful. Thank you for that. So just around the case management for working remotely. So some of the practicalities, that remote signing of agreements to mediate and things like that. Some of those things, in some ways, one of the positive effects of the pandemic was that most people now are relatively comfortable with getting involved with an online meeting. Most clients. That barrier to online meetings is a bit challenging. However, confidentiality, the issues around who's in the room on the other side of the webcam range, who can hear in the house, because unlike when you're doing mediation in your space where you can control that, when you're working with people who are at home or in other locations, we can't. And while you'd know on the platform, if they're recording with the platform tool, that there's nothing to say that they're not setting up and recording elsewhere. Ultimately, they can't use the information, like it wouldn't be admissible in a hearing or anything like that, but it is a breach of trust. Does anyone have any thoughts or comments about this issue? I think might have been in the group. Someone was saying that they had a client who was insisting on face-to-face because they thought the other person would record the meeting if it was online. We're all used to that now. Section 60I certificates, again, we know they're only valid for 12 months. There's a little bit of controversy around whether or not you just issue one at the end of the mediation. The guidance from the Attorney General's Department is no, we don't want to be giving them out to make it easy to go to court if they don't need to. Often there's going to be a clause in their parenting agreement about attempting to resolve any issues with the agreement through mediation before they try to go to court. So issuing a certificate isn't necessary. However, you need to make a file note so that if something does come up and it is reasonable to issue the certificate in 10 months' time, you actually know what certificate to issue and when the last mediation or attempted mediation was. So the other thing is we shouldn't just put parenting on there because they are only used for parenting. So the idea is in the section of the certificate that asks why did they come to mediation, we're putting a still high level but some basic information so that if other different issues come up, they need to go to mediation before they go straight to court. And again, in your case management, good question about what happens if you've only done one intake and only no issues from party A. Yeah, look, it's a judgment call. In most cases, I'd be wanting to talk to party B, but if there's some really significant risk factors that have come up with party A, you may make a call that you're not going to contact party B. It's, again, part of our principles around the case management is we look at each case individually and it fits within the framework of our obligations. So, yeah, because we understand that party A may have a vested interest in telling us a story. Oh, sorry. What to put on? You'd have to put it not suitable. You can't put that, you can't use A that party B didn't attend because if you haven't invited them, then they had no opportunity to attend. Yeah, you'd have to do a not appropriate. If you did meet with party A only and decided that you didn't think it was suitable and you weren't going to invite party B. But we need to balance that risk assessment with the concept that party A may want to go to court and so they may be telling us something that's designed to facilitate that process. So we don't want to be part of systems abuse, but the backstop is we know that in most cases the court, depending on their risk assessment, is going to send them to mediation or a conciliation process within the court anyway. And just with documenting agreements, FDRPs should not be drafting consent orders. Drafting consent orders is legal work, and we shouldn't be, if you're working with both clients, even if you are a lawyer, it's really not advisable. Yep, no problems, Mary. It's not advisable to be doing legal work for FDR clients. So my strong recommendation is stop at the heads of agreement. You can draft a really good heads of agreement you should draft a really good heads of agreement with all the details, and that's so that the lawyer who's drafting up the consent orders or the binding financial agreement doesn't have to have so many questions that it pulls apart the agreement. It's really important to make sure that you're only putting down what has been agreed. Sometimes when we get complaints, people might say this wasn't agreed, that the mediator may have gone later and justed it up so much that it doesn't really resemble what the client saw in the mediation. That if you think that's necessary, then it might need another mediation session, or it may need better management than just sending an unrecognisable document to people. And of course, the reality testing as you're doing it, which is again why your process should be working with the clients to get that agreement written. So will it solve the problem? Is it workable? Are they committed? And again, parenting agreements are not admissible. If they sign and date it, it's going to become a parenting plan. It is admissible as evidence, but it's not enforceable in that the court would need to determine how they're going to respond and make use of what was agreed and the compliance with what was agreed. So we need to remember those distinctions, and then that comes into your case management. Are you someone who's trying to get the people to sign the agreement on the day, or do you encourage them to reflect on it, get some advice so that when they do sign, it's very well and truly a solid agreement? Again, it may depend. And we're out of time. Remember the network, you can raise questions and share there, as well as in the Mediators Network. Thank you. And I will